Good morning, friends. Today I'm planning to share some thoughts on the direct tax dispute resolution scheme, which is proposed in the Finance Bill 2016. The Finance Minister in his speech mentioned that there are 3 lakh tax cases which are pending at the First Appellate Authority with a total amount of disputed amount of 5.5 lakh crores. From the direct tax perspective, the finance minister's annual report 2014-15 talks of uh, the appeals pending before CIT appeals, Commissioner of Income Tax appeals, where the total amount locked up in dispute is 3,83,000 crores. Keeping this in mind, the finance minister has proposed to bring and introduce a direct tax dispute resolution scheme. The finance bill proposes to introduce both direct and indirect tax dispute resolution scheme. The scheme basically tries to give an opportunity to the taxpayers to settle the disputes which are outstanding at the first appellate authority level. The intention is to look at the if you look at the direct tax dispute resolution scheme, the intention is to resolve the disputes which are pending before Commissioner of Income Tax appeals or Commissioner of Wealth Tax appeal as on the date of budget, that is 29/2/2016. Sections 199 to 208 of the bill contains the proposed scheme. Now we will look at the broad outline of the scheme. The scheme basically is split into two kind of dispute resolutions. One what they call as tax arrears and one what they call as specified tax. The tax arrears are the cases where the tax and interest or penalty is determined under the Income Tax Act and Wealth Tax Act, in respect of which appeal is pending before Commissioner of Income Tax Appeals or Commissioner of Wealth Tax Appeal as on 29/2/2016. So these are the cases where the tax authorities would have passed an order under 143(3) or 148. So these will be the cases where the assessments have been done, or these will be the cases where penalties have been levied. The second kind of cases are the specified tax cases, where the effect of retrospective amendment, the Vodafone and Crane kind of cases, where due to retrospective amendment, the tax liability is fastened for the prior years when the law was not in force. So these are two broad category of cases which these particular schemes try to resolve. Now we'll try to look at the cases, what is proposed for these two broad categories. In case of tax arrear, again there could be two broad classifications. One is about tax and interest, and second is about penalty. In cases where the tax and interest is where tax and interest is due for not more than 10 lakhs, the scheme proposes that the taxpayer shall pay whole of the disputed tax and interest till the date of the assessment and reassessment. The important point that should be noted here is the in cases where it is exceeding 10 lakh rupees, the scheme provides for a further levy of penalty at the rate of 25% of the minimum penalty. So the cases where the disputed tax is less than 10 lakh rupees, the taxpayers don't have to pay penalty. In the cases where the disputed tax is more than 10 lakh rupees, the taxpayers will have to pay additional 25% penalty. So these will be cases. So when we are deciding whether the case falls in less than 10 lakhs or more than 10 lakhs, only the disputed tax has to be considered and not the interest. This is the plain interpretation of the provision that is proposed. The law, a clarification on this would be helpful. Another point that should be noted is when a person is withdrawing or making a resolution for dispute, it will be for the entire amount or entire appeal and not just for a part of the appeal. So entire assessment or entire disputed tax has to be resolved by virtue of the scheme, and part of the resolution is not possible. In cases of specified tax, the whole of the tax determined has to be paid. So this will be something which will be determined in accordance with the scheme or where the notices have been served for the retrospective amendment cases. The scheme further provides that once the declaration is filed under this, in case of tax arrear cases, the appeal will be deemed to have been withdrawn. So the assessee will have no recourse under the normal provisions. However, in case of specified tax, the declarant who is trying to take the benefit of this scheme should withdraw the appeal and should file a proof of withdrawal of appeal before the designated authority. So any appeal or any writ petition which is pending before the High Court, Supreme Court should be withdrawn. Further, this scheme further provides that any notice which is pending under arbitration, conciliation, mediation should also be withdrawn, and proof should be furnished with before filing the declaration under the scheme. So therefore, these assessees will have to withdraw the writ petitions or the notices before filing the declarations, and then only the declaration can be filed. Similarly, in specified cases, another condition that has been provided is that the declarant shall furnish an undertaking that he shall waive all his right to pursue any remedy under the act or under the agreement. So even the remedy which is available under bilateral investment protection agreements should be waived. So this is an important condition which is attached in specified tax cases. So effectively the assessee, once he is entering into this scheme, he has to give away all his rights of appeal, writ or protection available under PIPA. Next, we need to understand that if there is a non-compliance or violation of the scheme, then what happens? The way it is provided is if the assessee has furnished in a declaration which is false, or if the conditions of the scheme are not satisfied, or if the declarant acts in any manner which is not in accordance with the scheme, it will be deemed that as if he has never furnished the declarations. Therefore, all the regular proceedings will revive. So all the assessment proceedings or appeals pending before the appellate authorities will all revive. So assessee will, and also the scheme provides that amount of taxes paid will not be refundable. However, there needs to be some clarification on this, that if the assessee pays amount under this scheme, that should be available as credit when the regular appeal proceedings are continued or when the regular the proceedings are revived. That clarification is required. Coming to procedural part of it, the scheme provides that the assessee, the designated authority, within 60 days of the filing of declaration by the assessee, shall determine the amount payable. So he will issue a certificate determining what is the amount payable by the assessee based on this scheme. So here again, some clarification may be required that while determining the amount payable, the existing taxes paid, the refund set-offs should be considered, and the only balance amount should be asked from the assessee. Once the assessee files this declaration, within 60 days, the designated authority will pass the certificate, will issue the certificate. Post issue of certificate, the assessee should pay the balance tax within 30 days of the receipt of certificate. Once the assessee pays this balance tax and furnishes the proof to the designated authority, the designated authority shall pass an order stating that the taxes have been paid, the declarant has paid the taxes. Such an order will be conclusive of all the matters under the scheme, and thereafter no proceedings can be taken up or reopened under the income tax or wealth tax against the declarant. So this is an important procedure where the order will be passed. However, the relevant rules and forms, I hope, will be notified in due course, which will provide for further procedure in terms of within how much time the declarant should file the declaration, how much time the scheme will be open, what are the forms and other procedure, who are the designated authority, will have to be notified. Once the order has been passed, the assessee get immunity from under the scheme from institution of any proceedings under the Act, Income Tax Act or Wealth Tax. He will get a waiver of all the penalties under the income tax or wealth tax. Similarly, waiver of interest. So currently he will have to, under the scheme, he has to pay interest up to the date of the assessment order. Post the date of assessment order, like interest under 220, etc., will not be leviable. Assessee will not be treated in default for those cases. So that immunity will be available to the taxpayer once the order is passed by the designated authority, post assessing making the declaration and paying the taxes under the scheme. However, the scheme will not be applicable to certain kind of cases. Section 205 further provides that this scheme will not be applicable in certain cases. So they try try to avoid cases, kind of taxpayers in whose cases the search has been done, for example, they cannot take the benefit of the scheme. So if the assessment or reassessment date is done in consequence of a search, such a taxpayer cannot take the benefit of the scheme. Similarly, if the assessment reassessment is as a consequence of a survey done, then the taxpayer cannot take the benefit of the scheme. Similarly, if for any assessment year for which a prosecution has already been started, then in those cases the taxpayer cannot make a declaration under the scheme. So these are three cases under the Act. Similarly, there is a exception given where the assessee, where the income is in relation to undisclosed income from a source or asset outside India, or where exchange of information is there under DTAA or exchange of information agreement, those cases will be excluded. Naturally, the last two kind of cases are already covered under black money law, where the assessees might have made a declarations. So those are tried to be excluded from this. Apart from this, where there are criminal proceedings happening under other laws, for example, under the Foreign Exchange and Prevention of Smuggling Activities, Indian Penal Code, the Narcotic Drugs and Psychotropic Substances Act, Prevention of Corruption Act, or where a person is notified by special court's trial of offence relating to transaction of securities, those taxpayers or those persons are outside the benefit of this scheme. So those persons cannot make any declaration in the scheme. So you have one set of exceptions for certain income tax under the income tax laws like search and survey. Second set of exclusions are for assessees who are for whom against any proceedings are going under other laws. So these are two category of persons who have been excluded for the purpose of this scheme. So to conclude, this scheme tries to it put forth government's resolve to reduce pending litigation. So the government has been moving in that direction by issuing a lot of instruction and clarification, trying to withdraw pending appeals. So it is a step forward in the same resolve. However, there are certain issues which will come forward. Like one of the issues is the government is expecting the taxpayer to pay 100% of tax and interest and 20 plus 25% of penalty where the amount outstanding is more than 10 lakhs. So here the cases where the assessee is expecting some relief from appellate authorities, from the judicial forums, those assessees may not opt for this scheme because they will expect that the relief is available based on the decided cases or judicial decisions or interpretation of law. Those cases may not really opt for this. If we look at Tax Sutra's book on TP analysis authored by Deloitte, in that cases only 11% of cases are in favor of revenue. So if you look at 89% are either in favor of the assessee or remanded back. So that itself indicates that the orders passed by the tax authorities may not be on strong footings. In such a circumstances, expecting assessee to pay 100% of tax may not make the scheme very successful. The assessees who wanted to buy peace by paying a part of the demand and a waiver of penalty would surely not opt for this scheme and continue with the litigation. Lastly, maybe this scheme the scheme is now currently restricted only to appeals pending at First Appellate Authority on 29/2/2016. It would have been better if it had been extended to the income tax appellate appeals pending before the ITAT, or maybe the cutoff date may be extended sometime in future, so that the appeals which are at the highest level or which may be instituted post this budget may also be covered under the scheme. So I think this scheme, this is all with respect to this scheme. Thank you.